returns if he's turning up. I have instructed. I was a partner at Tavendale's where he's employed. I get instructions from them from time to time, briefs. My wife, Eleni Limmer, QC, KC, I just put that on the end of it. She does quite a bit of work with Sam Chichi, but I don't, given that council, I don't consider that creates any realistic conflict. And of course, my decision will be made on the basis of the submissions and hearings that are presented.
Yeah. Any questions? As I said, I'll set aside myself from the matters in relation to the Papua War Memorial items. It's convenient if we actually hear the evidence. What you can be assured of is that those particular matters, those that are reclusive themselves just won't participate in the deliberation or decision-making process. It's a little bit easier if we, rather than shuffling people in and out of the room, as and when these matters might come up from time to time. So whilst we might be sitting here listening on those particular matters, we won't participate in the That's okay. I said I'm going to be away. As of Friday morning, I'm travelling overseas for a month, which is lovely for me, but very inconvenient for my Commissioner colleagues. But we have some time. I think the intention is to try and determine matters in relation to this plan change ahead of, and recommend to the Council ahead of the final Council meeting this year, is the intention, which I think from memory sets us a time frame around late-ish in August. We're confident we can work to that, even with my absence. So, should things change on that, we can advise the relevant parties within Council. And our expectation is that's not going to impede us achieving that outcome. Questions? Your hands. How do you want to run your show this morning? We've got a timetable. Do we follow that generally?
Yes, we'll generally follow the timetable. It will take a bit of time to go through the opening legal submissions, commissioners, and as you've noted, you haven't seen them, so I'll be reading out large passages of them. Some of them, though, are reference materials for you that I won't read. Before getting underway with that, can I confirm that you have all the information, the key information that makes up the council position at the start of the hearing? So what I'm talking about there is the set of provisions that went online this morning. I don't know whether they've been sent to you directly.
We haven't received an update. If they're different from what we would have had previously, we haven't got those.
So what's different about them is that maybe, Dylan, you can make those available to the commissioners. Mrs. Richmond was working on those yesterday. The part 6.3 of the plan updated to show the council position as incorporating the position from Mr. Langman's evidence, okay. Mr. Langman being the planner, yes. Christchurch City Council.
Yep.
So that's the council position as well at the start of the hearing. So the updated provisions show those changes. And they also incorporate the council position in relation to Antonio Hall and Desbury. So they show, they colour code those as being
council's position.
The council's position.
Okay, thank you.
Yeah.
So that just follows
is that one copy of those still?
Yeah. So that's one set.
That's one set. Would the commissioners like a hard copy of those?
Yes. We would each, thank you. Yeah. That's fine for now, but
and you'll explain those, Richmond, when you were talking.
And so we'll explain the council position. That package is about the council position.
Okay. Yes.
My recommendation.
Okay.
So we do now have those, yes?
Yeah, you've got those. Now the other thing is the final set of the residential heritage area maps. So that's making sure that you've got the one in particular that's updated showing the reduced size. So okay if I call it RHA?
Yes, absolutely.
RHA?
Possibly. Again, I'd have to go back and compare those graphics from when we produced them off. How long ago was that updated on the website?
I think we've got a hard copy of them.
If you've got a hard copy, that's fine.
Yeah.
If there's any dispute, just give us what we need.
But would you like to pass those?
I can't recall when I printed a copy off the website. It was probably over a week ago. It was after the 42A report was released, so whether it's the latest version, I don't know.
No, I don't know off the top of my head.
It's not immediately necessary, but I mean, as long as we can have that copy up, yeah.
Yeah. Okay, we'll look after that as a housekeeping matter as we
I
proceed.
suspect there might be other things that have moved a little bit on relative to recommendations and so forth that we might inquire about as we go through as well. So it might not be the last request we have. Actually, while I'm talking about, I have this was yesterday talking about a graphic that might be of assistance to us. And I'm going to describe it as best I can, but what we would really appreciate, and again, not immediately, may not even be necessary during the course of the hearing, but I'll describe it as a cascade graphic showing various activities in relation to both RHAs and items and settings that trigger the need for consent and a determinative of activity status. So, for example, if you're in an RHA and you want to demolish a particular categorisation of building, where does that take you? Containing provisions. Is it a consent required as a consequence of that? If so, what is the status of that consent? For example, are you following me? What I'm seeking? A family tree is what I'd call it, of a cascade of what happens, what does that mean, and where does that take me? And it can be quite graphic, almost as a cascading model. We just felt that would be a helpful guide, particularly if we're contemplating possible changes to that, either by recommendation through the evidence we're receiving or our own considerations. There's also, and we'll come to it through the course of this morning, various issues, questions around scope, which have relevance and a bearing on how that family tree might ultimately play out, particularly in relation to what we can and can't consider.
Are we touching on scope?
Yeah, sure. Cool. You understand what I'm asking?
Yes, we sometimes call it a wiring diagram.
That will do. So, yeah, same. It only has to be in summary form. It doesn't have to have word for word provisions within it. Just where does it take us if you do or don't do certain things? Okay, thank you.
Last general matter before I get into the legal submissions, commissions, I haven't introduced myself. My name's Brent Pizzi. I'm council, Christchurch City Council. And I'll introduce you to the City Council witnesses. First, we have Dr. Nick Ewan. We have Ms. Dixon to my left. We have Amanda Hose. And we have Mrs. Suzanne Richmond. And directly behind me, I think you've been dealing with Mr. Bridget over some housekeeping matters. Thank you.
It's possible and probable, in fact, that we'll have some comings and goings from, possibly not so much today, but certainly tomorrow. So we might have to just take stock depending on who's in the room at any particular point in time, particularly if they're lay people not familiar with these sort of forums, as to whether we need to offer some directional guidance for those individuals. Yeah.
Thank you.
Just one point in terms of the live streaming, no issues with that, obviously, but is that recorded as well? So will it be available for?
Yeah.
So that availability is live, as you say, or so we are.
Yeah.
And there'll be a captured recording of that available.
Yeah, we can upload to the website.
Is it available publicly to anybody?
Yeah, that's the plan, I believe. To report it
Yeah, I'm comfortable with that. So it's a public forum. I just And where's the camera? There. It's going to get a wonderful view of our left-hand side. Right. Your hands.
Thank you, Commissioners. You have a hard copy review of the Council's opening submissions. The matters I'll be talking to, just looking through the first page of contents. I'll be first describing the relationship between plan changes 13 and 14, because that's relevant to several matters arising in the hearing. I'll then be describing the Council's current position at the start of the hearing, under 4 headings. One is describing the changes that have been withdrawn from Plan Change 13. So I won't spend a great deal of time on those because you are deciding on those matters that have been withdrawn. The second one will be in relation to Antonio Hall and Dearsbury. Third, the Council position on the Council submission, which is a pretty straightforward one. And the Council position on all other matters, which is in line with the Council's evidence. The legal framework I'll describe very briefly because it's well known, except that I'll talk a little bit about some particular evaluative report matters that arise from Section 77J and 77P of the RMA, which are new provisions that are brought in because of the intensification planning instrument process. And there's special evaluative requirements that runs from. I won't spend a great deal of time describing the relevant planning documents because they've been set out in detail in the Section 32 and Section 32A. I will spend a little bit of time summarising the Council position on the key issues that were highlighted in the 42A report and will be further highlighted in the Council's evidence. So by way of introduction, Commissioners, the heritage objectives in the district plan are very well settled. The purpose of PC 13 is to make some changes to policies to more appropriately implement the objectives, and to rules and other provisions to more appropriately implement the policies. And Plan Change 13 does this in 4 core ways. It introduces what is now 9 RHAs, which are a new concept for this plan, but very well tested nationally, and Ms. Dixon will describe that. It introduces some new heritage items to an existing list of scheduled heritage items, an existing schedule of heritage items, I should say, in the district plan. It also schedules additional heritage interiors for those heritage items. And it proposes, as I said, some changes to policies and rules that are intended to improve the manner in which the provisions achieve the existing heritage objectives. So these aren't huge changes in the scheme of things for a district plan, as there's no changes to the objectives. I've described the matters I'll be talking to in these opening submissions. Turning to the first one, the relationship to Plan Change 14, I'll read out this part of my submissions from paragraph 4. So Plan Change 14 is the intensification planning instrument, I'll call it IPI, that the RMA requires councils to introduce. PC 14 proposes changes to the district plan to implement the medium density residential standards, I'll call those MDRS, and to implement policy 3 of the National Policy Statement on Urban Development. Council have been working towards notifying Plan Change 13 for some time prior to the statutory direction to notify an IPI. So when preparing Plan Change 14, the Council considered that there were ambiguities in the legislation about the scope of decision making that was possible in the IPI process. And there were ambiguities of High Court decisions. As a result of that concern over ambiguities and the scope of Plan Change 13, there is overlap between the provisions notified in Plan Change 13 and the provisions notified in Plan Change 14. Council notified those 2 plan changes at the same time, but the Council very deliberately held back on hearing Plan Change 13 until after the first set of the council and the minister decisions on IHP recommendations, independent recommendations on Plan Change 14. So, as is clear from that explanation, the reason for delaying the hearing Plan Change 13 was so that the council would be able to withdraw heritage matters from Plan Change 13 if they had been duplicated in the two plan changes and had been decided and determined in the Plan Change 14 process. Now, at the time of notifying the two plan changes together, council officers were also quite acutely aware that doing so would cause confusion for submitters. So council has treated all submissions that raised heritage matters as being submissions on both Plan Change 13 and Plan Change 14. Submissions were combined in that way in the summary of submissions for the purpose of further submissions for this plan change. Okay, now the IHP delivered all of its Plan Change 14 recommendations to the council, together with clarifications of a number of questions the council had about the IHP recommendations by November of last year. Decision making by the council on the IHP recommendations on Plan Change 14 is in two stages. Council has passed the first of those two stages. Central government intends to allow the council the opportunity to opt out of implementing some of the IPI recommendations, but not for intensification areas and around commercial centres. And this has been made clear by Minister Bishop. The Minister's timetabling directions to the council enable that separation and enable that consideration of opt-out. So the Minister's timetabling directions that the council had to make had to publicly notify its decisions on the IHP recommendations on intensification in and around centres, which I call the policy 3 areas, had to make those decisions, notify those decisions by December of last year. Current timetable directions that council has to notify its decision on the balance of the IHP recommendations by December of this year. So the council made decisions in December last year on the policy 3 matters. The council decisions that rejected IHP recommendations by statute go to the minister to decide, and the minister issued his decision on those disputed matters, I think 2 weeks ago. So the council has made its decision on the policy 3 areas, but in doing so, it also chose to make decisions on Antonio Hill, on IHP recommendations on Antonio Hill and Desborough.
Why did it do that?
Why doesn't matter, Commissioner. It simply decided it wanted to do so at that stage. It had the option.
Entitled to do that.
It was entitled to do it. Yeah.
Sorry, that's a better question.
Yes. Yeah. So the minister's timetable directions latest deadlines had to publicly notify a decision on policy 3 by December of last year, has to publicly notify by December this year on the balance. But it was totally open to the council to bring some of that decision making forward if it wanted to. Yeah. Have you got any, would you like to ask any questions on that aspect of the submissions at this stage?
No, not really. There's a little bit of crystal ball gazing about what's going to happen. I see it's noted in terms of the potential for the Plan Change 14 issues more relevantly, but they impact on heritage issues to be, to be more in council's control, if you like.
Yes.
I mean, it's just crystal ball gazing at the moment, though, isn't it?
Yes, we don't know how it's going to land at this stage because the Select Committee just reported back last week with some recommendations on what the opt-out provisions would look like in the Act. When I say opt-out, I'm talking about the council opting out of making a decision on the balance of PC 14. And there will be minimum requirements in order for the council to have the statutory ability to opt out. And we don't know exactly what those minimum requirements are going to be, or whether they will be met.
We are where we are, and will be as we advance through our work until August.
Yes.
You may come onto this, but in terms of what we should or could consider around final decision making in advance of things that are yet to be determined either by statute change, council, or the minister. In relation to Daresbury and Antonio Hall, is what sits before us currently. Live matters, irrespective of the potential for that to change down the track.
Yes. I'll come to. I'll read through my submission.
Yes, sorry, I might be getting
that might be the best.
But where I'm going is I just want absolute clarity as to what's in and not, if you like, in terms of our scope for consideration or determination. Yes.
Returning to the council's current position, in the legal submission starting at paragraph 11, I describe the council's position under 4 heads. First is the changes withdrawn from Plan Change 13. The second one is Antonio Hill and Daresbury. Then the council position on the council submission and the council's position on other evidence. Now, Part A, changes withdrawn from Plan Change 13 because of decisions on Plan Change 14. There have been 3 council resolutions that have done this. First, on the 11th of December last year, the council withdrew some amendments to the extent of some heritage items and removed the proposed scheduling of the Algest War Memorial Hall and removed 2 residential heritage areas. Also made some changes in relation to one of the inner city west residential heritage areas.
Sorry, it's contemplating those withdrawals in
Yes.
terms of exclusions, if you like.
Yes.
So it's nothing subsequent to what we've already received that's come about.
Yeah. Well, with one exception, I think when I run through this, and that's the resolution of the 4th of June.
Yeah, okay.
Significantly in that council decision on the 11th of December, it withdrew some packages of rules, if you like, to do with interface provisions around 5 of the RHAs. And also, quite significantly, all area-specific built form rules for RHAs. Now, I emphasise that because it's relevant to some concerns raised by submitters to do with overlapping provisions between character areas and RHAs. So that withdrawal of built form rules for RHAs addresses that in my submission to a considerable extent. There was then a council, this is council resolution on the 16th of April that reduced the size of the Lyttelton RHA, and a further council resolution on the 4th of June that withdrew maximum height overlays in relation to the Regent Street Arts and the Arts Centre, and heritage interface matter in relation to those areas. It removed the Catholic Cathedral as a heritage item because it's not there, and it further reduced the Lyttelton RHA. And there's I've given you a link to a map if you wanted to try a copy of that reduced size.
Yes, for Lyttelton particularly. Yeah.
Now, I'll read through these submissions. What I've got here, Commissioners, I cut and pasted into a memo that I delivered on Friday last week. So you have seen this word for word, but I'll read it out. Response to the questions.
Just before you move on, can I just ask a question in terms of the withdrawal? Those matters are not before us at all.
Correct.
So if there's a submission, for example, in relation to Lyttelton RHA seeking its extension, is that within our scope or not?
So If the submission is seeking a further reduction of the Littleton RH. Well, so I'll just go back a step, Commissioner. So the Littleton RHA is still for you to consider. It's simply a reduced size than what it was at the time it was notified. So you're deciding on that reduced size proposed by the council for the Littleton RHA. Now, if a submission asks for further reduction of it, in my submission, there is scope to hear that. If a submitter asks for expansion of it, I'll be touching on later in my submission on scope case law, but in my submission, there will be people affected by that who haven't had the opportunity to submit. There haven't been any written submissions that have asked for expansion of the Littleton RHA, as far as I recall. I think Ms. Dixon will correct me on that if needed. And so in my submission, there isn't scope for expansion.
Generic sense, that's a defining comment around scope generally in respect of particularly RHAs. We were talking about boundary, if I could call it boundary adjustment, either in or out. Yeah, okay, well, I'm sure we'll have other questions around the scope of specific situations, but generically, I'm hearing what you're saying.
The only example I can think of for that at the moment, Commissioners, is Dr. McEwen's evidence notes that there is some value in adding some houses on Barbados Street to one of the RHAs. So I'll touch on that on my submissions, and in my opinion, that's outside scope.
Yeah, Ryan Street was another one, which was
Yes, it was. Yeah.
Yes. Thanks.
Going to Antonio Hill and Daresbury. The council position on continued scheduling of Antonio Hill and Daresbury differs from the Section 42A report planning recommendations. The council determined its position on the heritage scheduling of Daresbury and Antonio Hill in December 2024 when it considered the IHP recommendations on Plan Change 14. Notified Plan Change 14 continued to schedule those two heritage items and their settings as a qualifying matter that warranted lesser development of those sites than is otherwise enabled by the MDRS. Submissions sought the removal of them from the schedule of heritage items. Council's evidence in PC 14 was broadly the same as the Council's expert evidence on them for this hearing. The PC 14 Independent Hearings Panel recommendation to Council was that they remain scheduled in the plan as a qualifying matter. On the 2nd of December, Council made decisions on the IHP recommendations for the intensification areas that is required by Policy 3 of the NPS, and that's intensification in and around commercial centres. Now, Daresbury and Antonio Hill, as I said, are not within the NPS Policy 3 intensification areas that the Council decided on in December 2024, but elected members decided to address them at the same time because they wanted to determine the merits of scheduling them in advance of deciding on the remainder of the IHP recommendations on PC 14, as they're entitled to do. So first of all, turning to Daresbury, I've referenced the Council resolution of the 2nd of December. That Council resolution was to reject the IHP recommendation on PC 14 and to recommend to the Minister that Daresbury and its heritage setting not remain scheduled in the plan. Council recommendation report to the Minister, which is a public document, and I've got a reference to it there, said, quote, Council considers that the house has been damaged to an extent where it is uneconomic to repair, as reflected in the evidence of the landowner. So that's the record of the Council decision making on this and the reasons for it. Now, the Minister's decisions on the Council's recommendations on PC 14, where the Council hadn't accepted the IHP recommendations, those Minister decisions were released on the 5th of June. Minister Bishop said he declined to make a decision in relation to Daresbury and Antonio Hall, and his letter saying that he declined to make that decision, said it was because the council has not yet made decisions on the zoning of these areas. Minister said, I intend to consider these 3 referred recommendations, referring here also to the PICO residential character areas, once the council has decided on the zoning for those areas. He further added, the council may refer these decisions to me again ahead of deciding on the balance of Plan Change 14. So the minister has declined to make a decision on Desbury and Antonio. They are still, that is then it's still a live issue in PC 14. But it is also a live issue in PC 13.
Who has the decision-making authority in respect of the 2 properties? Could we conceivably end up where we've got 2 independent hearings bodies making different decisions in relation to the same matter?
Yes, but at different points in time.
Who's first?
So just thinking about the hypotheticals of the way it might play out. Plan Change 13 hearing is underway. You're going to be issuing a decision, you've said, by
Recommendation.
Issuing a recommendation, correct, by August. Your recommendation then goes to the council for the council to make a decision before the local body elections. If you've made a decision on PC, if you've made a recommendation on PC 13, the council can either accept or reject that recommendation. So the ultimate decision on your recommendation, obviously, is the council's. If for whatever reason, council at PC 13, on the basis of your PC 13 recommendation, was to accept your recommendation to retain scheduling of those 2 buildings, then that is the PC 13. There may still be a PC 14 decision that is yet to be made.
Which could differ.
Which could differ.
But subsequently.
But it would be the same council.
Yes.
Which is making that decision.
When's the election?
Well, that's the same entity.
Yeah.
The same entity. Yeah.
Is the PC 14 evidence in respect of Desbury and Antonio Hall evidence in respect of PC 13 as well? Is the evidence that has been received by the independent hearings panel on PC 14 in relation to those 2 properties evidence before us as well?
Yes.
Because people have relied on that, you would have seen it.
Yes, they have. Yeah.
So why do you say that? Is that because it's adopted?
Because the witnesses refer to it and they have it as evidence.
The reasoning and decision making of the independent hearings panel and the council in its resolution to differ from that recommendation equally before us as evidence within.
I've referred to it as public information. I've referred to it in my legal submissions.
Action plan
As it exists. No witnesses for the council are referring to it because it's simply a legal matter. It's part of the background. And its context. You still, the decision of this, the recommendation that this hearings panel makes is a recommendation on the evidence you hear on the appropriateness of the provisions and the listings in PC 13. It is a separate matter from other council decision-making processes.
Yeah, just in terms of the PICO residential character area, which is referred to in the recommendation, that's that's not before us, is it?
No.
And why is it not? Because that was a pure PC 14 matter, was it?
Character area and
Character area. Okay, thank you.
And the evidence before us in support of the council's resolution to not follow the independent hearings panel's recommendation is simply the resolution.
Correct.
And nothing more.
Correct. It would be wholly inappropriate for council experts to try and speak for the council about the council decision-making process. The council decision-making process is recorded in a staff report that went to the council, and the minutes of the council meeting, and the report that council then delivered to the minister, which included that passage that I described a moment ago in paragraph 19 of my legal submissions. That is the record of the council decision making. So the views of anyone else about it, or speculations by anyone else about it, is inappropriate.
But the experts are entitled to, as you've said, I think, but the experts are obviously there to give their opinion, and there's no constraints on us considering their evidence.
Correct. Their opinion about the matters within the areas of expertise to do with the two buildings, not their opinion about council decision-making processes.
And it's a live issue because it remains in front of us for determination.
Correct.
The council conceivably could have chosen to withdraw Dewsbury, Antonio Hall, and anything else from PC 13 at the time it made its resolution to differ from the IHP's recommendation. Could have not.
The PC 13 notified some additions to the schedule for heritage items, 43
Yes.
additions. Antonio Hill and Dewsbury weren't additions; they were already in the district plan. So the council hasn't notified a plan change, which adds Antonio Hill and Dewsbury.
So would they have any scope at all or entitlement to withdraw from consideration in PC 13 either of those properties?
So that's my submission that the council would not have had the ability to withdraw Antonio Hill and Dewsbury from consideration in PC 13 because the descheduling of Antonio Hill and Dewsbury arises from submissions.
Neither proposed under PC 13 or 14. Yeah. Okay.
Okay. That's cool.
I think so. Right. So just so I'm clear in terms of the scheduling of those two buildings, they were not promulgated by council. They came in as a result.
They are scheduled in the operative district. So descheduling them came in and scheduled.
Yeah. Okay.
So the scope is to deschedule them or not under the submission framework.
Yes.
Council itself didn't have that available option unless it chose to somehow re-notify or do a different plan change to bring that into play and go back to the appropriate stage of the process to do that subsequent to its resolution.
Yes.
If it wished to. That's how it would have had to have done that if it didn't.
Yes, correct.
Right. Thank you.
21 was it?
21. So if the minister's decision on the PC 14 had been to accept the council's recommendation to not retain the scheduling of the items, then the council would have withdrawn them from PC 13.
Yes. So that would be able to mention what is it. That's an avenue to remove, if you like.
Yeah. As the matter has not yet been resolved in PC 14, the council position in PC 13 is in support of the submitter's request to not retain the scheduling of Dewsbury, as it is, in the council's words, uneconomic to repair. The council's neutral, independent experts are providing their expert opinions relevant to this matter. However, there is no dispute between the council position and the position of the Dewsbury submitter. Antonio Hall is my submission case broadly the same. I refer to the council resolution which was to reject the IHP recommendation and recommend to the Minister that Antonio Hall and associated heritage setting is removed from the heritage schedule. And I refer, as I did for Dewsbury, to the council recommendation to report to the Minister. And in this case, that report said, quote, council considers that the building is significantly compromised and the site is better placed to deliver housing given its highly accessible location. Describe to you the Minister's decision on both Antonio Hall and Dewsbury. So as I said in relation to Dewsbury, or Antonio Hall, the matter has involved in PC 14. The council position at PC 13 is in support of the submitter's request to not retain the scheduling of Antonio Hall, as the building is, the council's words, significantly compromised and the site is better placed to deliver housing given its highly accessible location. Council's neutral independent experts providing their expert opinion service this matter. There is no other expert evidence on it. The council position differs from the planning recommendation. I deal much more briefly with aspects of the council's position, commissioners. So first, the council position on the council submission is in accordance with the recommendations of Mr. Langman, who's the planning witness appearing for the council as submitted. In paragraph 28, I summarise the changes that he recommends, and they're recorded in the hard copy that's been handed to you. And
attendance is scheduled tomorrow. Sorry,
sorry, yes, his attendance tomorrow. And
wasn't the earlier version.
Very fast today.
Apologies, sorry.
Now the council position, lastly, in terms of the council position on all other matters, that's in accordance with the recommendations of the council experts. Turning to the legal framework appended as A and B to these submissions, is a summary of the legal framework, which is standard in these matters. Commissioners, so I have to go through those. But I am going to refer in a little bit more detail to, in addition to that framework, which is relevant to PC 13, to legal extensions. The Act's provisions regarding plan changes that constrain medium density residential standards and constrain the intensification that's enabled by policy 3 of the NPSUD. Relevant here. And these are section 77, starting with section 77G, which provides that every relevant residential zone in a specified territorial authority must have the MDRS incorporated into the zone, and also must give effect to policy 3 in that zone, policy 3 being intensification in and around commercial centres. Effective plan change 13 is to make heritage sites and heritage areas less enabling of development than would otherwise be enabled by the MDRS and by policy 3 of the NPSUD. Section 77I provides that plan changes can constrain that intensification only to the extent necessary to accommodate one or more qualifying matters that apply to the area. That qualifying matter is a new term coming through these provisions. One of those qualifying matters specified in section 77I is, quote, a matter of national importance that decision makers are required to recognise and provide for under section 6.
So that legitimises the higher level of constraint, effectively.
Yes. So that's the statutory basis for there being a higher level of constraint. If the requirements for the evaluation of that constraint are met. So I'm turning now to the requirements for that evaluation. Paragraph 37. Section 77J3 for residential zones and 77P for non-residential areas contains additional requirements for evaluation or areas where a qualifying matter is proposed, as it is here. Those sections say that the evaluation report must demonstrate why the territorial authority considers that the area is subject to a qualifying matter, and that the qualifying matter is incompatible with the level of development that the NDRS or Policy 3 provides for the area. The evaluation report also must assess the impact that limiting development capacity, building height or density will have on the provision of development capacity. And C, must assess the costs and broader impacts of imposing those laws. Now, I've emphasised that those additional requirements, because they are new, and you may not have come across them before, I don't know, but what it means for this plan change is that those evaluation requirements apply to the heritage officers, the RHAs, that are within the Policy 3 areas that the Council has made decisions on. So it doesn't apply to all of the RHAs, because as I was saying before, the Council hasn't made decisions on all of the plan change for 14. It's only made decisions on the intensification areas in and around centres. So if we're talking about, if you're considering a heritage item or a residential heritage area that's within those Policy 3 intensification areas, that extra evaluation requirement applies. Paragraph 38, I've said what those are. There's 2 RHAs, Chester Street and Dawson Street RHA, and the Inner City West RHA.
Yep.
And it's 6 new items in sentence.
So in addition to your normal Section 32A evaluations, these are additional requirements where that particular overlay applies.
Yes.
Relevantly to these particular matters, to particular individual properties or areas. Yeah. So in addition to determining what we would normally determine under a paved plan framework, we have to layer upon that the added evaluation, given what's legitimised by the Act provision.
Yes.
Yeah.
Mm-hmm.
And in paragraph 39, I tell you where you can find that in the evidence. So in Ms. Dixon's evidence, Ms. Richmond's evidence, and I refer here expressly to Mr. Osborne's summary evidence,
Right.
paragraph 18.
As we said, if we haven't considered that, reviewed it, thought about it, if we have reason to talk to Mr. Osborne about that, we can still try and arrange that.
Yes.
Yes.
So you might want to have a look at that before you decide at the end of the day whether you want to hear any of those expert witnesses tomorrow.
I think they're on notice that we may want them anyway for tomorrow. Yeah.
Yes.
Okay.
The next part of the legal submissions, commissioners, are about the scope to make changes to plan change 13. There are a few issues arising in relation to this. As you all know, the hearings panel has jurisdiction to recommend changes to plan change 13 in response to submissions. In order for it to do so, the changes must be within the scope of the submission, and the submission must be on the plan change. So that's 2 lumps. The other changes within the scope of submissions. In paragraph 41, I set out the legal test for whether change is within the scope of the submission. And in paragraph 42 onwards, I set out principles from leading case law on whether a submission is on a plan change. Would you like me to take you through those? From paragraph 47, I then apply that to some of the scope issues.
I think it might just be worthwhile if you just took us through the leading authorities, if you like.
So the leading paragraph 42 of the submissions, the leading authority on whether a submission is on a plan change is the High Court decision in Clearwater, which sets out a 2-limb test for whether the submission is on a plan change. First, the submission must reasonably fall within the ambit of the plan change by addressing a change to the status quo. as advanced by the notified change. And secondly, the decision makers should consider whether there is a real risk that persons potentially affected by change sought in a submission have been denied an effective opportunity to participate in a plan change process. And it was that second part of the test that I was referring to, especially when I mentioned Dr. McEwen's suggestion for adding some further properties to an RHA. With it coming in at this stage, there are people who are affected by that and they haven't had the opportunity to participate.
There's a clean cut, if I could put it that way, between PC 14 and the withdrawal matters that have been withdrawn from PC 13, you highlighted earlier. Anything in relation to evidence that was presented at PC 14 in regard to any of those matters, if that was the case, is to also be disregarded.
Yes.
So if they were, for example, if they were seeking to extend or include a slight difference relative to those individual properties or areas, that's not scope for us to bring that back into plan change 13.
Yes, I agree that is not scope. Yes, yes.
Sorry, I'm aware of that double negative.
Yes, but because looking at the look of RHA, there have been very significant reductions in those proposed by the council in the size of that RHA. So that's in the council's evidence here, but the RHA has been reduced. It is, as a matter of fact, now proposed by the council in PC 13, much smaller than it was. Yeah. So if you've got a submitter who's talking about one of the houses that had been withdrawn from scope PC 13, that's relevant. If someone's talking to expanding the area beyond the edge that was originally notified, the council has already pulled that back. Yeah. That's outside scope. It would have been outside scope anyway. It is simply not for you.
Okay, so just so I'm clear on that. So are you saying if there's if there is a submission which seeks an extension, that's not within scope, is it?
Yes, right.
Because it's not on the plan change, is that?
Yes.
Unless a submitter sought that. No, you're saying even sorry, not unless, irrespective of whether a submission sought that extension, because there hasn't been the third party opportunity to participate, that's no longer in scope. That's not within scope.
Yes, that's my submission.
So if somebody is has filed an original submission which raises that extension, you see that goes out for public notification, and there's the opportunity for further submission. So yeah, I'm just trying to understand how that works, because that's and it's something we just need to think through. And I can't think of a live example, to be frank.
Well, I don't think there are any live examples.
I can't think of one at the moment, but there are matters, for example, like with the Memorial Avenues, one of the submissions seeks extending that the protections to the houses.
Yes, beyond the road reserve and
that's right.
To the adjacent properties.
Yeah. And that in my submission, I've got a paragraph in here on that in my submission is outside scope. And that's not just because of expansion, it's because it's a different topic. The notified proposal is in relation to the streets, the trees in the streets, the plaques in the streets, the avenues themselves. The notified proposal has got nothing to do with the buildings that join the streets.
So conceivably, even if that same submitter or another had sought the extension of a street or an additional bit of a street or another street in relation to the same matter, i.e. memorial trees and plaques, your submission is that would be beyond scope because parties haven't had an opportunity to consider it, even if it was in an original submission.
Perhaps I'll come back to, I'll give that some thought and I'll come back to it. Well, I'll run through the scope issues that I have identified here.
While you're thinking about that, another is the dimension is the categorisation of buildings within RHAs. For example, if we were to what ability, if any, scope-wise, is there us to play around, if I could put it that way, between those various categorisations of buildings, if at all?
Sure. Okay. Paragraph 44 is referring to Justice Costs and the Plumston North City Council Automated Machinists decision in relation to the two limbs as to whether the submission is on the plan change. First limb clear test is the dominant consideration, and this involves two aspects: the degree of alteration to the status quo proposed by the notified plan change, and whether submission addresses that alteration. In other words, whether the submission reasonably falls within the ambit of the plan change. Justice Cost also noted that the Section 32 assessment is a comparative evaluation of the efficiency, effectiveness, and appropriateness of options. For variations advanced in submissions to be on the plan change, they should be assessed in the Section 32 assessment. If a change advanced in a submission is not a matter that either was addressed or should have been addressed in the Section 32 evaluation, then the change is unlikely to meet the first form of the testing. And Justice Cossell and Motor Machinists also talked to the matter of procedural fairness, which I've been concentrating on. Is whether there's a real risk that persons directly or potentially affected by the additional changes proposed by the submission, in that case described as submissional sideways, denied an opportunity to respond to those proposed changes. In the words of the court, in that case, it would be a remarkable proposition that a plan change might so morph that a person not directly affected at one stage might then find themselves directly affected but speechless at a later stage, under the third-party submission not directly notified. So what if they see that level of unfairness that militates the skills? So if the effect,
Sorry, just in terms of the scope issue, there have been some environment court cases, and I can't recall what they are, but they've sort of queried some of the machinist reasoning in terms of Section 32 analysis. I'm not going to go fishing for cases, but you're saying that the principles and the two leading cases, if you like, remain applicable.
yes. Yeah, the environment court, the principles, yes. There's various, the court's decisions on these are very fact specific, and so those principles are applied in different ways in different cases.
So that's a key. That's a key aspect for us to consider, that it does vary from, so it's fact dependent.
Yes, yes, absolutely.
Well, thank you. Sorry to interrupt.
No, please do ask questions.
Should have said at the outset that that's very much what we'll do. Apologies.
No, thank you. Yeah. We will apply that leading authority to the facts here and get down to some of the specific items that I've noticed and I'm not sure whether it's captured everything in your minds, Commissioners, but it's the ones that I've maybe take advice to discussions. The first one is to do with the submission that was lodged by Ceres. Is that how you say it? Ceres. Lodged by Ceres. This issue arises from the further submission, which sought to expand the original submission by adding a new provision for a controlled activity status for demolition. And it's referred to in Mrs. Richmond's, slightly there, sorry. It's referred to in Mrs. Richmond's Section 42A. The notified plan change 13 had no schedule for significantly damaged buildings, and the notified provisions had the same rules for those as for any other heritage items. The Ceres original submission sought a new schedule for significantly damaged buildings and an associated policy and rules framework. The original submission point sought to restrict discretionary activity for demolition of buildings in that schedule. Ceres then lodged a further submission on its own submission seeking controlled activity status for demolition of buildings in that schedule, where the building has a section 124, which is a date of building notice issued under the building. Mrs. Richmond's section 42A analysis excuse me, rightly highlights potential scope issue because the further submission seeks different relief than that sought in the original submission that it supports. However, in my submission, the panel is entitled to consider the evidence that Mr. Joel presents on the merits of that change and consider whether that additional relief he recommends is within the scope of the original submission. Paragraph 52. The original submission sought a special activity status for a subset of heritage buildings, being significantly damaged ones. And it's reasonable to expect from that the panel will reconsider whether that activity status or another activity status is appropriate for all or part of that subset of heritage items.
Is that because status per se has been raised and clearly so in the original submission? So up or down, if I can put it that way,
yes,
as a realistic available option to consider.
Yes. And even if it hadn't been raised in a submission, the council had notified a proposal that it be a particular activity status. If the council's evidence didn't play out sufficiently in support of that, it would made a different recommendation.
That's distinguishable from a situation where a boundary may extend outwards to bring third parties who previously haven't had any involvement. Is it distinguishable?
In my submission it is, because it's about very much fine-tuning of the appropriateness of the provisions of the Act rather than expanding the scope of people who might be affected by something. So paragraph 53 is my opinion on that submission on that, Commissioners. Granting that relief as a foreseeable consequence of the relief sought. Next one, reducing protection for Daresbury and Antonio Hall. So this is referring to Amanda O's evidence adopted in the Section 42A planning recommendations, which favours reduced setting for Daresbury and reduced coverage for the structures that comprise the Antonio Hall item. The Section 42A report notes that this is a possible scope issue as it wasn't sought in submissions. The council position is that submissions seeking that those items be removed are within scope. And consistently with that, if the any evidence from Amanda O's about reducing the size of those items or protections in those items will also be scope.
I'm not sure on either count scope-wise. We're here. Joel. Later tomorrow, is it?
Yeah, I think that's tomorrow.
Are you going to be here for that? Are you going to be present? Yes. Yeah. I have some questions around that that may have a scope relevance, but I'll save them till then.
Yes.
About the completeness of the relief sought. May not be actually be a scope issue. It might be more about that. But sorry, I was thinking aloud. Yeah, if you're present, I may have some further questions that come back to relevance around the scope as well.
Okay. Now, I think that, as Mr. Corporal noted, the application of the principles regarding scope is very fact specific and context is important. From paragraph 56 onwards, I describe some in my submission important contextual issues. First is the paragraph 57, the wide terms in which plan change 13 is described in the section 32A report and public notice. And in paragraph 58, I quote the introductory section of the section 32 report, which describes the purpose of plan change 13. I won't read that out. In paragraph 59, I note that explanation at the start of the start of the section 32 report doesn't expressly refer to removing any heritage items from the schedule. But the issue statement in the section 32 report stated that the plan change included deleting some items from the schedule because they had been demolished or because resource consent had been granted for demolition. Quote that passage in footnote 25. Section 32 report section headed description and scope of the plan change had a list of 5 purposes, one of which is to, quote, correct the schedule of significant historic heritage items to reflect changes in circumstances over time and to correct errors. It further noted that there are a number of corrections to the schedule of significant historic heritage items, including to the heritage aerial maps showing items and settings. And I then referred to the public notice issued on the 17th of March 2023, which was the full page public notice, a joint one for PC 13 and 14. It described, made some very broad statements about the content of the plan change. But then paragraph 62 had a detailed list of plan changes in that joint statement. And it included 2 items in particular about plan change 13. One is Roman numeral 8, protecting heritage areas across the city to recognise Tautahi Christchurch's special identity, introducing each one list of the state's 11 RHAs and 44 buildings and items, 26 building interiors. Also simplifying and clarifying heritage provisions and strengthening rules, including minor changes to some policies. So secondly, in terms of the contextual matters, is the complexity and confusion arising from the duplications and overlap between plan change 13 and 14. And applying some of the text from the cases I referred to earlier, approaching scope issues here in a realistic, workable fashion rather than perspective of legal niceties as my submission warranted. Thirdly, the range of changes proposed in PC 13 include changes to policies and laws, additions and amendments to heritage schedule, removals from the heritage schedule, determining appropriate sizes and locations of RHAs, determining what status applies to specific buildings and specific activities within RHAs. Fourthly, and certainly not least, the merit of removing Daresbury and other items from the schedule was expressly discussed in the Section 32 report. And I emphasise this because of one of the principles I noted earlier from the cases. Scope, if it's talked about in the 32, is probably within scope. And Daresbury, the merits of removing Daresbury in particular, was discussed in the Section 32 report.
Thank you, just back. Well, I've got it on my mind. That in your paragraph 59, we make reference to the explanation in the Section 32 evaluation. Being constrained, if I use those terms, by or specific to deleted items that have been demolished or where a resource consent's been issued. As you advance through your points thereafter, is that an overarching constraint? So anything thereafter that discusses removals is bound by those qualifiers?
No, I don't think it is, Commissioners. No.
And that's because, I'm putting words in your mouth here, that's because those expressions themselves aren't bound by that. So they're examples, if you like.
They're examples, yeah. There wasn't space in the newspaper and when notifying Plan Change 13 and Plan Change 14 together to set out every precise change.
So your submissions, they're not constraining thereafter. We've got whatever the reason was found to be, removal is a legitimate scope.
Yes, that is And lastly, persons in relation to removals. The submissions seeking removals from the schedule were publicly notified and people had the opportunity to make their submissions and submitted. So in my submission, paragraph 67 requests to remove items from the schedule are within the scope of PC 14, within the scope of PC 13. Correct typing conditions. 67. Not submissional sidewind. However, additions to the schedule of the heritage items or the size of RHAs are in my submission widening the plan change and so not on the plan change. Here, where there has been, there are two proposals to add new heritage items. I'm referring here to my last sentence in paragraph 68. Here, the owners of Spraydon Lodge support the council submission, seeking that it be added to the schedule of heritage items. So I'm referring here to the principle that the zero person adversely affected by this, or the owner of the building supports it. And I'll add to that, I refer to it later in submissions, a building called Teddington Lockup. There was a submission that sought that be added to the schedule of heritage items. It's owned by the council. The council supports it being added.
Up to it, we've observed that there's a number where conversations perhaps remain incomplete. Either approaches have been made to owners around their consents or awareness or otherwise, and we might question individuals about that as to whether there's been any follow-up. There were a few examples that I can't think off the top of my head of anyone specifically where we were informed of those discussions or approaches, but they hadn't seemingly been resolved. Just for those that are listening, witnesses wise, it might be helpful to us to hear if there's been any subsequent updates since the report was prepared around those, because it may have material relevance if whatever that outcome might be, if there's an acceptance, for example.
And the council's experts and the council position is that they not be listed if the owner
but
not be scheduled.
Scheduled as opposed to doesn't apply to RHAs is our
not be scheduled unless the owner agrees.
So if those conversations haven't run a course or remain incomplete, we might just test some of that as to updates. It's relatively minor.
Can I just jump in here and just for my understanding and clarification? In your section 58, you are saying that the primary purpose of the plan change is to better reflect aspects of the city history and development, adding to the schedule of the heritage items, and adding further interiors and introducing residential heritage. In 68, you say additions to the schedule of heritage items is actually widening of the plan changes, and you think it's out of scope. Wasn't that initially the purpose? And if so, does that only include initial submissions that have been made in terms of new items that should be on the schedule?
I addressed it in these submissions, Commissioner, only in relation to where a submitter has asked for a new item to be added. So a submitter has asked for a new item to be added and the owner agrees with it being added, then the concern in the scope case law about people being adversely affected by submissional sidewinds doesn't arise because those people are involved in the process. So simply as a matter of practicality, I do quite like those words, not always taking a perspective of legal niceties. No one's adversely affected by that, so that's appropriate. But if you had a submission that was seeking to expand a residential heritage area or add items and the owners of those buildings aren't involved, then in my submission, it's simply unfair and should not be granted.
Thank you.
Paragraph 69, I refer to each of the potential scope issues that have been noted in Ms Dixon's 42A report. So that's RHAs. First one I've mentioned already, Dr. McEwen's suggestion that 3 cottages on the Labour Street could be included in the Chester Street RHA. The council position in my submission is that there isn't scope for that. Second one was Dr. McEwen's recommendation to exclude some buildings from the inner city west RHA. It's an exclusion, so it's inside scope. Next one, Dr. McEwen's suggestion that an area based around Ryan Street does meet the criteria for an RHA. That's an addition, it's outside scope. Next one, Dr. McEwen's evidence recommended changes to the rate within the plan of properties within the RHA, and you mentioned this a moment ago, Commissioners. From Dr. McEwen's table, all of those rating changes are downgrades. But no one's affected more by her recommended rating changes than what was notified.
That was partly why I asked for your wiring diagram, because if we play around, my words again, alter, change, if there's scope to do so, those relative categorisations, what's the consequential effect in terms of imposition on anybody in relation to seeking to do an activity? Your submission is, if you're downgraded, you're probably okay.
Yes.
What's your submission on the alternative?
I haven't got one at this stage. We will put some thought into that.
I'm not signaling anything predetermined there. I just want to know whether if that situation was to arise for us. One, have we got scope to do that? And two, what are our considerations in making that determination? It occurs that one of those matters might be the degree to which it imposes on a landowner or anyone else seeking to do an activity thereafter. Mike, is that clear?
Yes, it is. Yes.
I mean, that's not a particularly urgent matter, but it's a relevant matter.
One of the interesting things, I'm not trying to form this question, but there are some submissions that are essentially wanting inclusion in RHAs and matters like that, or additions to it. So actually sort of seeking greater control over their own properties, which is perhaps unusual. I don't know whether it has any legal relevance or not. When you're talking about the matters of scope, and if somebody's willing for their property to be scheduled and it meets the heritage requirements, then yes, we'll do it. But yeah, I found it interesting in general discussions that they want an additional controls basically on their own, on the areas in which they reside in.
I don't think I've addressed those specifically as a scope issue here because, if I remember correctly, none of the council's expert evidence doesn't, Amanda's evidence doesn't support adding any of those where the submitter has asked for it. Have I got that right? For those? Okay. We'll come back to that, but I haven't told them as a scope issue because I think that was dealt with evidentially as not stacking up under the heritage criteria.
But notwithstanding the fact that we might disagree with that, there's two issues here: what the evidence supports and what's available to us as scope.
Yes, but on each of those buildings, I think the only expert evidence available to you is from the council sources.
It might be the only expert witness, but it's not the only evidence.
Correct. Yes.
So scope's still a live issue irrespective. Yes. Yeah.
And Roman numeral 5 at the top of page 19, my last point in relation to Ms. Dixon's evidence is referring to Dr. McEwen's section 42A report recommendation to remove sites from the Littleton RHA. As I've said, that's not an issue for this year. Turning to Mrs. Richmond's 42A analysis, it raises potential scope issues concerning submissions seeking removal of protection for some items and sectors, Thatchers, Antonio Hall, and Desiree. position in my submission is that the submission seeking removal from the schedule, so items and settings are within the scope.
We're at that point, just conscious of the time, we're sort of tracking at or about what we were scheduled for the morning too. I don't know how you feel about what's your expectation of.
Probably got another half hour to go.
If we take a break, tragically, it puts us immediately behind time. But if it is that, yes, I'm just conscious there's a reasonable amount to go. We're adding to your load by our questioning. So maybe we take the morning tea break and follow up after that.
Any questions?
So let's take a 20-minute break and we can pass through to about Q2. Yeah.
Commissioners, I had finished the part of my written legal submissions in relation to scope. In the break, Dr. McEwen was speaking up, answering one of your questions about scope, I think. Dr. McEwen tells me that she's checked the submissions in relation to the Littleton RHA, and there were no submissions that sought to expand the Littleton RHA. So that issue didn't arise there. It potentially does arise, though, as a scope issue in relation to Chester Street East RHA, because you'll be aware of submissions that sought to expand that. I haven't addressed that here as a scope issue. Dr. McEwen's evidence that that expansion didn't stack up on the criteria. But as a scope issue, I'll address it in the council's reply. The next section, legal submissions, is the relevant planning documents. I won't spend much time on that. You are aware of being commissioners. At paragraph 73, I quote the passage from the section 32 report, which is setting out the objectives of the Canterbury Regional Policy Statement, which must be given effect to by the district. That's the ones that are relevant to heritage matters.
These are not disputous.
Paragraph 74, I refer to the Christchurch Central Recovery Plan, which is a relevant matter, but nothing more. At 70, or must have regard to it, actually, rather than a relevant matter. At paragraph 75 and onwards, I refer to the Council's own heritage strategy and its goals and its actions. And at paragraph 78, I quote the Gospels from the HLA report, which are a nice useful summary of the weight and the approach to those directions of those three conditions as a reference point.
That strategy is a matter we have regard to.
Yes. Yes, must have regard to. Yes. Now, I'd like to spend a little bit of time running through my summary of what you will have seen in the section 42A report and the council's evidence of the experts' advice on the key issues. And here, these are the council position and the expert advice. I deal with them in two sections. First, to do with residential heritage areas, starting at paragraph 79. So the residential heritage area section 42A report identified 6 key issues and contention. I note in the footnote there that there were 8 listed in that report, but 2 of them were then subsumed within other issues in the way it was fleshed out in the 42A report. I then provide a summary of the BPIS Council's position and evidence on each of those issues. First of all, that RHAs do not have unique features. Paragraph 81, the criteria for proposing that an area be subject to RHA provisions ensure that the RHAs do have special heritage value. And I set out there the criteria from that have been applied and will be applied in the district plan. The area must fulfil one or more of the council's standard heritage assessment criteria. It has to incorporate a collection of elements that together address the interconnectedness of people, place and activities. It has to contribute to the overall heritage values, identity and amenity of the city. It has to have a coherent heritage fabric which meets recognised criteria for heritage assessment. It needs to demonstrate authenticity and have integrity applying to both tangible and intangible heritage values. It must contain a majority of sites or buildings that are of defining or contributory importance to the heritage area. It has to have been predominantly developed more than 30 years ago and include no less than 15 properties. Dr. McEwen's evidence and the detailed heritage reports for RHAs provide extensive evidence of their heritage values of these areas. Next submission point that I address is that RHA represent inappropriate regulation. And submitters have referred to the strategic objective in the district plan for minimising consent processes. Now that strategic objective is given effect to through other chapters of the plan. Those chapters and provisions include the heritage objective, which is unaltered by Plan Change 13, of not solely facilitating use and reuse, restoration and reconstruction, but also maintaining the overall contribution of historic heritage to the district's character and identity through protection and conservation of significant historic heritage. Ms. Dixon's planning evidence is that because of the extensive loss of heritage in the Canterbury earthquakes, what is left is relatively more significant than previously. And she applies that to RHA identification, since so many potential areas have already had their heritage values eroded. The next submission point that I address under this head is that RHAs conflate character and heritage. I've touched on that previously in these submissions, referring to the provisions that the Council has withdrawn from Plan Change 13 in relation to billboard standards. Concern about the difference or lack of difference in proposed provisions for character areas and heritage areas was an issue in PC 14 and remains live in this hearing, but the Council has addressed it in part by withdrawing RHA build form rules from Plan Change 13. The Section 42A assessment sets out the key differences between RHAs and character areas. RHA assessment focuses on 6 values, including historic and social value and cultural and spiritual value, which are non-visual values. Physical expression of heritage values is of course relevant, but this is assessed through a historical lens. E.g., for architectural values, the values being looked at are those associated with a particular style, period, or design values. Council's evidence is that the high threshold set by the assessment criteria for potential RHAs means that the line which meets that criteria and remain in PC 13 are the best examples of possible RHAs and are the residential areas of most historic significance to the city. Next, I address submissions concerning the appropriateness of the inner city west RHA applying over school zone land, which is quite a precise issue addressed in Dr. McEwen's evidence. Her evidence is that those properties do make a significant contribution to the heritage values of the city, and excluding them from the RHA would be inconsistent with the Council's heritage methodology and criteria. And Ms. Dixon agrees with that assessment.
So that principle can apply not only just in the one example of the City West, where we might have open space areas or whatever that might form a component part of the RHA. So the identification is not contingent on it being a residentially zoned area necessarily.
Correct.
Although predominantly they might be.
Paragraph 88, that submitter also raised the relevance of the school having certificates of compliance for demolition of the buildings that they own in that proposed RHA. By submission, these will be relevant if demolition is proposed, but in the meantime, those sites and buildings continue to contribute to the heritage values and identity of the areas. Next, submissions challenging the existence or boundaries of notified RHAs. The council position on these as summarised in the RHA section 42A report. And I then break that down into the council position on each of those RHAs. The Chester Street, Dawson Street RHA, council's evidence agrees to reduce the boundary at the Fem site. So that's resolved. For the Macmillan and RHA, the council position is that 20 Macmillan Ave should remain in the RHA due to Dr. McEwen's evidence of its values. In relation to the Inner City West RHA, submissions by the Carter Group and the Catholic Diocese challenging the definitions of defining contributory, neutral and intrusive buildings in RHAs, saying that vague or uncertain. Dr. McEwen's evidence addresses that in detail. Our submissions challenge all aspects of RHAs, and these are the issues that I've broadly discussed above. And there was a submission point regarding 31 Cashel Street. Council believes that they should remain in the RHA as defining building. Next RHA is the Church Property Trustee Auburns RHA, and that's that was Park. Dr. McEwen's evidence in the council position is that the area as a whole demonstrates significant historic heritage values and a high level of authenticity and integrity that warranted remaining as an RHA. With regard to your specific address, 48 Melbourne Street, raised by submitters, due to the modifications to the building described by that submitter, Dr. McEwen recommends that it be classified as contributory rather than defining. That's one of the rating changes we were talking about before. With regard to the Rugby Park and Melbourne Street properties raised in the submission by the Football Union, Council position is that the evidence is that they should remain in the RHA. The development history of the park is integral to the history and heritage significance of that RHA. As for the 642A report, and in particular Dr. McEwen's evidence. Last two of the RHAs, in particular Shirley Forbes RHA, there was a submission regarding Kelly Street. No change to the council position that it should be identified as a contributory building. There was a submission regarding Forbes Street. The council evidence is that it doesn't have the requisite heritage value to warrant including it in an RHA. So this was one of those other extension RHA submissions that we were talking about, Forbes Street.
Sorry, so it does have the requisite value.
Oh, it does. Sorry, it does have.
So the submissions request in regard to that.
I'll come back to that, Commissioner.
Cool. Retain. Yeah, sorry, just.
Sorry, I'll have to come back to clarify that and come back to you on it. And I mentioned the Littleton RHA again with issue 2, seeking more RHAs or expansion of RHAs. We've talked about that in relation to scope issues. Dr. McEwen's evidence is that none of the new RHAs proposed in the submissions or submissions seeking expansions to notified RHAs meet the criteria for being an RHA, for reasons such as the extent of modification and redevelopment of the growth. And the third issue concerning RHAs is the amendments to RHAs rules so that they are less restrictive, and I deal with that under several heads. First is to do with removing defining or contributing or neutral categories raised by some submissions. In the council's evidence and submissions, removal of those categories would undermine heritage protection. Dr. McEwen's evidence explains the two reasons for that categorisation. First being to establish whether a potential area includes a sufficient number of defining and contributory elements to embody significant heritage values, and secondly, to enable a nuanced planning response to facilitate protection of heritage values. Removing those categories would defeat those purposes. Next submission point, that RHAs wrongly have the practical effect of scheduling buildings. The submissions that raise this are challenging the proposed drafting of 3 policies and the rules and matters of discretion that implement those policies. The submitter's concern is that the policy framework applies the same policy tests for RHA buildings as for scheduled heritage items. Ms Dixon's Section 42A assessment and the Council position reaffirms the need for provisions to manage the values of individual defining and contributing buildings. Otherwise, the remaining values of the RHA could easily be cumulatively degraded over time. The Section 42A report also acknowledges that changes to the notified provisions are appropriate so that there's a primary focus on the collective values of the heritage area, with only a secondary focus on individual buildings. Those drafting changes were set out in the 42A report and are the Council position at this stage.
It's just a relativity bias that's expressed in the provisions themselves, not dismissing one or other, but if you're like leading one particular way as a priority.
Yes. Next is concerning submissions regarding demolition policy and rules. The notified proposal is that demolition of defining or contributing buildings is a restricted discretionary activity. Several submissions propose that demolition be a permitted activity. The Council position is that permitted activity would make the RHA protection void, as the values of the area could disappear as a permitted activity. However, Ms Dixon's 42A report accepts that it's appropriate to amend the notified policy 93228 and matters of discretion for it to provide a clearer distinction and provisions between scheduled items and unscheduled buildings in RHAs. Ms Dixon's 42A recommendation also is to introduce a non-notification rule for demolition of contributory buildings. As she sets out those changes in the 42A in the bundle in front of you. Next point raised by submissions concerned providing permitted activity for improvements for sustainability purposes. Ms Dixon and the Council accept that. The 42A report agreed with the merits of that and proposed in the 42A exception to solar panels, etc., or double glazing. Next, providing permitted activity for alteration to neutral or intrusive buildings. Yes, the Council's evidence and position agrees with this point. Issue 4 raised by the submissions on RHAs sought clarification of RHA rules. Review of requests for minor amendments so that the rules work better. First one was that the plan provisions or standards should describe within the plan itself the specific heritage character of each RHA. Ms Dixon's planning assessment is that this would be difficult, unwieldy and inappropriate. The heritage reports describing the values of the areas are living documents. The reports themselves, I'm saying, are living documents subject to change outside of the district plan. Now, those reports will be publicly available, so they don't need to be in the district plan. Next submission point sought removal of overlap between some rules in relation to alteration of scheduled heritage items and unscheduled RHA buildings. And the Council's evidence accepted the appropriateness of doing so, and Ms Dixon has made those recommendations. Next one concerns correction and upgrading of Dr. McEwen's building contribution ratings. Dr. McEwen has recently checked and updated her 2022 work on all contribution ratings in the RHA, and she lists those changes in Appendix 2 to her 42A report. I don't address miscellaneous clarifications. Or zoning and around RHAs. Zoning is outside the scope of this plan change. I'll touch briefly, lastly, in relation to RHAs on submissions that sought changes such as economic incentives or resource consent fee rebates or compensation in relation to provisions that are seeking heritage protection. The relief sought in those submissions is the jurisdiction of decision makers on plan change 13. They're not district plan matters, they're matters for the council separately. This decision making on annual plans and long-term plans under the LGA. With one possible exception, and that's that there is a policy in the district plan that already refers to providing incentives, including financial incentives and technical advice to assist in achieving heritage outcomes. So that's an unaltered policy.
It's not the state.
Yeah, it's not. I then turn to issues raised by submissions concerning heritage items and settings. Mrs. Richmond's items section 42 report analyses submissions under 5 issue headings, and I deal with each of those in turn, summarising the council position on that. And these the nature of this plan change are quite specific points about specific properties. And if you like, the way I've summarised this for myself is ticks and crosses in relation to the council position. So first, Princess Margaret Hospital. No, the council does not support it being included. Secondly, the former court buildings. No, the council does not support amendments, does not support it being scheduled. War Memorial Plaque in Rigdon. There's always evidence that does not meet policy criteria. Tenanting lock-up, I've mentioned this before. So this was one raised by submissions. The council owns it and agrees to it being scheduled. Mrs. O's assessment that it does meet the policy criteria. And Mrs. Richmond recommends scheduling it. So the council position is that that is within scope, it's supported by the owner. Burnside Stable was raised by the same submitter. Ms. O's assessment is that it meets the criteria for being scheduled, but the owner at this stage, and you mentioned this before, Commissioner, my understanding is the owner at this stage hasn't supported scheduling it.
So that's a question in terms of that issue. It's one that comes up in terms of the owner's support. Is that identified in the policy framework at all, or is it just a matter of practice?
I would need to come back to you on that, and perhaps one of our experts can answer it, but I don't think it's covered in policy, so I think it's a matter of practice.
Okay. I'll raise it now and the witnesses can address it. Thank you.
The scope response, please. As to whether it could be. I can't recall if anyone's even addressed that matter by way of a request for any change.
Okay. Well, what exactly as to whether there's scope to
make a policy reference to that matter of practice?
Oh, okay.
Or not.
Mm.
As I say, I can't recall whether it's a specific matter that somebody's asked for or not. But is it on the, I guess, is it an available option to us?
Mm.
Yes.
I'll read paragraph 112, Commissioners. Several submissions oppose aspects of new and operative schedule. The Council position on those is that all of the items and settings that PC 13 proposed adding to the schedule have owner support with the job. And Ms. O's has assessed all as meeting the policy line 3221 criteria for heritage items. Those criteria themselves are based on national and international best practice and have been developed with reference to definitions and criteria, including those in the RMA, the ECOMOS New Zealand Charter, and the Heritage New Zealand Act. The Property Economics CEA cost benefit analysis in the Section 32A report and Mr. Osborne's report in the 42A describes the broad economic benefits to the city of heritage protection. Last two specific items, I think. One in Akaroa. The owners requested removing the operative land protection for the setting. However, the 42A report recommendation and the council position adopts Amanda O's recommendation to retain the operative heritage setting.
So the practice of not scheduling where an owner hasn't agreed, how does that compare here?
Yeah, well, perhaps Ms. O's can answer some questions about that.
At face value, it appears to be a distinction here.
Yeah, it does appear to be a distinction between the council's practice in relation to listing in the first scheduling in the first place, and then subsequently removing.
It's not a scope issue. You're talking about taking away something.
That's right. Paragraph 114 concerning Taylor's mistake batches. So the plan change notified proposed to add 25 batches to the schedule. Statements of significance for each proposed batch and Ms. O's evidence established that they meet the significance criteria for the schedule. The operative district plan heritage item schedule contains links to the heritage aerial maps and statements of significance for the batches that were in the operative schedule prior to plan change 13. Now, with regard to various submission points on the Taylor's mistake batches, first, heritage protection is consistent with the RMA Section 6D matter of national importance for public access to and along the coastal marine area. The council is satisfied that there is adequate pedestrian access on walkways along council land. Secondly, Taylor's mistake batches on council land rely on a licence to occupy from the council. The council is not granting those licences if unmitigated land instability and rockfall risk makes occupancy of those batches unsafe. Mrs. Richmond's opinion and the council position is that the plan change 13 proposed permitted activity for demolition if the council has not granted a licence to occupy is efficient and the effect pragmatic. Just to emphasise that, what we're describing there, what I'm describing in those submissions is batches that are sitting on what is public road. It's not fork road, it is public land. The batches are there at licence from the council, because the council is granting formal licence to occupy them. The council isn't intending to grant licence to occupy batches that are still significantly affected by risk following the category earthquakes. Rockfall risk, unmitigated rockfall risk, for example. So if the council isn't granting a licence to occupy a batch, no one can use it. It's simply going to fall into disrepair. So it's perfectly appropriate in my submission for the council to have a permitted activity enabling demolition of these batches.
And that's the discretion of the council. They can exercise independently of the district plan.
Yes.
Either at a point where those licences might be up for reconsideration or at any point.
Yes.
Yeah, that risk profile changes or is found.
That's right. Hapanui War Memorial Avenues. Notified heritage item is street trees, plaques, and the road reserve of 16th Street in Hapanui. It doesn't include the adjoining houses. Submission seeking heritage protection for adjoining dwellings should, in the council submission, be rejected. Amanda O's assessment describes the reason for this and that the dwellings are not part of the heritage significance associated with the street trees. Amanda O's evidence and the 42A report also describe the appropriateness of the heritage scheduling treating the avenues, including old and replacement trees and plaques as a whole, rather than separately considering each tree or plaque. And Roman numeral 3, some submissions have raised good planning points about detailed drafting of these provisions, and 42A recommends making changes to address some of those points. That's Commissioner, that was Ms. Hellinger's submission.
I might be participating in that, but others will. I mean, there were other submissions. It wasn't his alone, but there were others.
Yes. Paragraph 117, Sydenham Cemetery. 42A report proposes fixing errors in the mapping of the heritage item. Now, I note, Commissioners, that you've pointed out that there may be scope issues in relation to that, because the mapping errors were that the mapping didn't include the entranceway to the cemetery. So that's mapping area is an expansion of the area of the RHA. So I'll come back to you in the council's right of reply in relation to scope issues concerning.
Yes, and you could probably be thinking about it already, but what ability, if any, into what clause, whatever it is, minor corrections allows us to rectify such matters if that in fact qualifies under that. And that's just one example, and conceivably there might be others where that provision is relevant to us to consider. For example, the number of matters that Mr. Langman covers of his evidence, I question whether potentially, not predetermining that, but whether there's relevance to the Schedule 1 ability or powers in relation to some of those matters.
Thank you.
The cemeteries reserves.
Cemeteries reserves. We'll come back to you on that.
It's not critical, but I'm just interested in knowing what their own plan, etc.
Yes, I'll come back to you on that. I won't talk again about items issue 2, which concerns Guestbury and Antonio Hall. I've covered that earlier on these submissions in detail. Issues item 3 was changes to protection for some items. Submission seeking changes to 2 items and settings. I agree. Issues item 5 were those submissions that oppose or change provisions to make them less restrictive. Submissions challenging Plan Change 13 on the basis that it's unduly increasing restrictions for heritage items, or is contrary to the strategic objective of minimising consenting requirements, seem in my submission to be either misunderstanding or exaggerating the level of restriction proposed by PC 13. All changes to provisions in Plan Change 13 that increase restrictions regarding heritage sites are as follows. First is building code repeated repairs. These move from being permitted repairs to being heritage building code works. And as heritage building code works, reconstruction and restoration, it moves from being a controlled to a restricted discretionary activity status if the permitted activity standard for a heritage works plan is not met. Third, removing the non-notification rule for heritage building code works, reconstruction, restoration and temporary buildings. This will mean that the consent authority can publicly notify proposals which have a more than minor adverse effect. Lastly, adding a limited number of permitted activity standards. I submit that this is a very moderate change to consenting requirements. When placed in the context of other changes proposed in Plan Change 13 that reduce consenting requirements, Mrs. Richmond predicts that the net increase in consenting requirements will be negligible. I then referred to a submission regarding the rights identified for various suites and illustrates site-specific provisions to maintain the status quo for the site. And the council evidence and position does not support doing so. Next, provisions for significantly damaged heritage buildings. Submissions oppose Plan Change 13 deleting provisions that provide less restrictive consenting pathways where there's damage from the 2011 earthquakes. Ceres seeks a special schedule of earthquake damaged buildings. Mrs. Richmond's evidence describes the minor changes to consenting processes that arise from the notified provisions. Given the 14 years since the Canterbury earthquake sequence, it is appropriate for the plan to return to more business as usual provisions. There's no need in my submission and the council evidence for special provisions addressing the earthquake legacy in this regard. Appropriate provisions for addressing earthquake damaged buildings was considered in drafting the Plan Change 13 provisions and in the Section 32 report. As Ms. Richmond notes, the operative and notified heritage policies and matters of discretion for heritage items allow for consideration of the condition of buildings and engineering and economic factors, and matters of discretion for heritage items and settings. Plan Change 13 provisions that you're considering, Commissioners, have been in legal effect and in Mrs. Richmond's assessment operating successfully for 2 years. And as noted earlier in these submissions, the series further submission sought a special controlled activity status for demolition of significantly damaged buildings that are subject to a Section 124 Building Act notice. That is a notice that the building is dangerous, affected or unsanitary. Mrs. Richmond's assessment establishes that that addition is inappropriate. Demolition is not the sole way to address Section 124 dangerous building notices. Demolition may not always be the most appropriate response in RMA terms. There might be reasonable alternatives to demolition. Plan Change 13 as notified enables that appraisal in the consenting process. The controlled activity status would prevent it.
This question will probably come up when we talk more specifically about the relief sought. Is it your understanding that the acknowledgement that Ceres want around buildings damaged by the earthquake is limited or confined to those subject to a Section 124 Building Act notice?
Yes.
So that defines what is a significantly damaged building.
Well,
is that per se, or is that just in relation to the controlled activity status?
Well, I'll come back to you and maybe we can flesh that out in the evidence a little bit more. But my recollection was that it was they wanted permitted activity. If a building, if the council has issued a 124 notice, it is permitted to demolish it.
Yes, I'm just not clear in my mind whether that was all they wanted by way of recognition,
Okay.
And if so, was it? If there was other recognition requested, was it limited to that same suite of buildings? And it's possibly, it will be a question I'll ask them directly, but I just wonder whether So it's been unclear in my mind to this point.
And then in paragraph 1 to 9, I refer to some submissions that have raised issues with Rule 93411 P11, reconstruction and restoration, and P12 for temporary lifting of damaged heritage items. Some submissions oppose Plan Change 13, deleting those rules and amalgamating them with others as a restricted discretionary activity. Mrs. Richmond explains that from her experience over the past 14 years, the restricted discretionary activity status will more appropriately enable assessment of alternative methodologies. Turning then, Commissioners, to submissions in relation to various definitions. There's the definition of alteration. The change proposed is for clarity. It doesn't, in the Council's submission, increase the types of change covered by the definition. It simply better expresses the type of work that may impact on heritage values. Secondly, demolition. The changes do not introduce a new test or threshold to the definition. The change appropriately focuses on heritage values rather than scale. That's the intent of the change. Thirdly, in relation to the definition of heritage settings, Ms. Richmond's recommended change, prompted by Mr. Cleese's planning evidence and 42A report, is the Council position at this stage. So the Council is picking up on Mr. Midge's point here. And does so again in relation to heritage fabric. There are changes proposed in the Council's evidence in response to the submitter's point. Into submissions raising issues with policies, some submissions propose changes to the policies on the basis that the changes broaden the scope of the policies. Mrs. Richmond's planning assessment establishes the appropriateness of those changes in my submission. Her opinion is that the notified provisions clarify the demolition policy so that it better supports the operative activity statuses for demolition. The changes strengthen the policy in the sense of being a stronger basis for rules to implement it. The policy changes are not increasing constraints and making the rules framework less enabling, as the activity statuses for demolition of heritage items are not proposed to change. However, she does propose an addition to the demolition policy, and I set out that proposed addition. She considers that this provides better direction for implementing the policy, and that is the Council position also at this stage. Lastly, rules and matters of discretion regarding heritage items. The notified permitted activity rule 93411P8 for alteration, relocation or demolition of a building, structure or feature in a heritage setting, where the building, structure or feature is not individually scheduled as a heritage item. Heritage New Zealand sought a change to that, but the Council's evidence and position is that the notified permitted activity status is more appropriate than the restricted discretionary activity status that was sought by that submitter. Closing these rather long opening submissions, I think the topic is the most appropriate objectives and policies. And I set out the legal test for what is most appropriate. The courts have often described the comparative test by asking which is the better option or outcome. I submitted that retention of the status quo is not most appropriate, and neither are the amendments sought to PC 13 proposed in submissions that have not been accepted in the Council's evidence. The Council's Section 32 report, Section 42A report, at this hearing explains why notified PC 13 is altered with the recommended changes in the Council's planning evidence is the most appropriate or better outcome. That evidence considers and responds to submitter requests seeking change provisions and explains why those requests are not the most appropriate. And I would add to that again that the council position is different concerning Antonio Hill and Desbury than the council evidence I was referring to in that paragraph. And lastly, I list the witnesses who will be appearing for the council.
Thank you. Appreciate it was long than you might have anticipated. Very helpful. Thank you. It's a bit of homework to do, obviously, but we would look forward to receiving whatever you reply on those particular, largely around scope issues.
Yes. Yes. So the council will be replying to those in the right of reply. The summary of the issues, commissioners, I prepared that as a reference point for you because they are very comprehensive Section 42A reports. So my intent here was as a reference point for these sort of passages concerning council position on those topics.
There's a number of places, sorry, you talk about council's position at this stage. Is that simply?
I don't mean. I was going to say I don't mean anything in particular by that, but yeah, the council position or a party's position in a hearing often changes as a result of further consideration by experts as a result of questions that are raised in the hearing, or there might be, you might want to have some expert.
It's just a general statement.
It's just a general statement. You might want to have expert witness caucusing.
Okay.
The first witness for the council is Ms. Oates.
I've got a crack at your pronunciation. O's. Is it? Oh, sorry. Just the wrong piece. O's is correct. Thank you. Yeah. Obviously, we've received your circulated contribution to the planning debate, but you have done a summary statement. I think we've got. Thank you. These were provided to us. What's your intention to take us through that? Is that a preference? Yeah. We'll probably adopt the same approach that influences immediately jump to our minds to budget. Apologies if that's breaks your flow. But sometimes it's easiest for us to do so rather than trying to capture them. So, yeah.
Prepared evidence on behalf of the council which responds to submissions seeking the removal of descheduling, the amendment or addition of parental item, and settings in schedule 3.7.2 in terms of policy 9.3 to identification assessment of scheduling parental item. I reaffirm that I am complying with the Environment Court's Code of Conduct for expert witnesses in presenting the summary of my evidence and responding to the submissions. Scheduled heritage items and settings. My evidence is based on an understanding of the heritage values of these places, as outlined in the statements of significance and relevant information held in council heritage files, including historical documentation and non-scheduled places. I've relied on heritage research documentation and council's heritage files, and including in some instances additional research and advice provided by in regard to my evidence for submissions seeking descheduling. I've also relied on the evidence of the range of experts who have provided the council quantity surveying and heritage engineering and conservation architecture. In the following paragraphs, I summarise my opinion on the various changes to the schedule. I do not support the removal or the extension of the Capital and War Memorial avenues because I consider they meet the scheduling policy. I support an amended name for the heritage item, which clarifies that the tree avenues, parks, and road reserve are equivalent item. I support amendments of heritage settings for Rickerton Tea House with revision of what is sought and the heritage setting for 27 Landover Road because these amendments reflect the current environment and still provide for the heritage values of the city. I support changes to the statement of significance for 47 but do not support an amendment of the heritage setting as there have been no changes to the setting that justify its removal. I do not support the scheduling of the 20th Battalion and 20th Regiment War Memorial or 111 Hackney Road as I do not consider they meet the threshold for scheduling. I do not support the scheduling of the Barnett Avenue Pensioner Flats or the Upper Rickerton War Memorial Library as these have been demolished. Although the former law courts, the Princess Margaret Hospital and the Burnside Stable, or Macquarie Stables, meet or are likely to meet the threshold for scheduling in terms of the heritage significance, it is not appropriate to schedule them at this time for reasons related to current works underway and potential engineering and financial factors.
Sorry, I'll just ask you a question there, just in terms of that. So it's the multitude of factors. It's not simply, you're not simply relying on the lack of owner support.
No, it's a variety of factors. It depends on the place. So I've simply tried to summarise.
Yep.
So that all of those factors don't necessarily all relate to each of those items. Detailed. I do support the scheduling of the Teddington lockup and setting as this meets the scheduling policy. I do not support the removal of 9 Ford Road, 129 High Street, 159 Manchester Street, 35 Rata Street, 25 proposed batches of Taylor's Mistake, or all operative and proposed scheduled Taylor's Mistake batches as sought in submission 96, as I consider these are justified scheduling. I do not support the removal of heritage items 463 Antonio Hall or Deansbury setting. However, I do support a reduction in the extent of heritage item 463, the Antonio Hall, to exclude the original homestead building and central wing, which have been destroyed by fire and are beyond. Based on the evidence of Stephen Hogg, I consider that accommodation wing and chapel are repairable. I consider the proposed amended item meets the threshold for scheduling as a significant heritage item. Consider that necessary works for repair and strengthening of Deansbury Homestead at 9 Deansbury Lane will retain its heritage values with some reduction of technological and its overall significance. I have reviewed the submitted evidence dated 6 June 2025 and do not consider there is any information contained within that alters my evidence. For the reduction of the setting of Deansbury in order to recognise the recent residential subdivision and development that has occurred within the area of setting to the north of the Wairarapa Street. I support I support a remapping of the boundary of proposed heritage item Sydenham Cemetery to include the entrance gates and the site of the former citizens' dwelling. I provided evidence for PC14 regarding Spraden Lodge, which is relied on in the evidence of Marcus Langman for this hearing. My opinion regarding Spraden Lodge remains unchanged. I have a couple of corrections to my evidence in chief. To amend paragraph 107. As this relates to legal advice which has now been superseded.
What's your preference?
The paragraph should be replaced with, sorry,
Yeah, no, Karen.
this paragraph should be replaced.
I'm telling you to stop it. I'm telling you to carry on. Somewhat contradictory.
So paragraph 107 should be replaced with, I note that with the operative notified heritage scheduling in place, in order to promptly address the safety issues, the owner may be able to apply for retrospective resource consent for the demolition of the fire attached west section. And I would like to delete paragraph 130. Regulation change. This was included in error. It's no longer relevant. It refers to a grant scheme, which there is no provision for. Council's current long-term plan.
That deletion in full.
It's not because there isn't grant scheme or funding available in the grant scheme. Your evidence, your submission is it's not relevant for us to consider that. Why are you deleting that?
The paragraph says that there is a grant that the works for Deersbury would be eligible to apply to the council's incentive grant heritage incentive grant scheme.
It's like we do, there's just no money in it. What I've clarified is there's still a grant scheme, it just currently doesn't have any money. Is that the position? Because the policy refers to that.
That's accurate.
Yeah, okay. Sorry, it's just a clarification. The grant scheme still a valuable option.
Finish response to submitted. Yeah. I've reviewed the evidence of Otto Snip, and I hope I have that pronunciation correct. If I don't. Dated 17th of June 2025, and I do not consider there is any information contained therein that alters my evidence with regard to supporting the scheduling of batches which are currently scheduled or proposed for scheduling. In part 2 of this evidence, Otto Snip provides commentary on the statement of significance of the batches. In response, I consider that the statements of significance for the batches are based on adequate, reliable, primary research sources and provide an objective assessment using the heritage values set out in Appendix 9.2.1 and the thresholds set out in Policy 9.3.2.1, identification, assessment and scheduling of heritage items. I consider that the built fabric of the batches, including later alterations and additions, evidences their historical. There is no requirement in Policy 9.3.2.1 for heritage items to be unmodified. And heritage conservation practice recognises the evidence of time and contributions of all periods. Although the statements of significance note that batches are built along the coastline, In response to Mr. Smith, I consider that these could be amended to explicitly state that public land is, I think, is relevant.
Very much. Questions. The process for amending those that supported information around statements of significance, they're sitting outside the commission, so they're a matter of public record, but able to be altered, adjusted, updated, whatever, through a process that doesn't require change. Yeah. All right. Questions? Give us a moment. We could compile ourselves around what we thought we might want to ask you versus what they've told us. Generic statement that'll follow through for the next 2 days, possibly worse as we progress.
I guess I just have one question that you
You should.
that relates to the question that we had earlier with regards to the owners of the agreement of the owners of items. Does that only apply to items? One. In how far does it relate to heritage areas? And if it relates to items, what's the difference between an agreement to schedule the building or to have a certain setting included?
Question is, yes, this call it a practice of only putting forward new items for scheduling with owner support, only relates to items. That's the only context.
It's not a practice for areas.
No, I thought it was for settings.
In terms of the settings, well, if we're proposing a new item, it would be items and settings. Support or a new item and setting. Associated setting. For all our currently scheduled items, they all have associated settings, or if they don't, then they've been assessed as not having a relevant setting. In a scenario, we would be looking to add a setting to an already scheduled item.
What about a scenario, sorry to break the thought, where you've got a scheduled item and setting and the owner opposes the setting but not the item? I don't know if that's a situation hypothetically that occurs, but
Sorry, that was the setting.
Right. Okay. So where the owner hasn't agreed to both the setting and the combination of a setting and an item. What I'm asking is the practice around not scheduling without owner's agreement. How does that play out in a situation where an item and its setting are scheduled and an owner may disagree with the setting, say, but not the item?
Well, the way in practice, it's only related to when we propose new items. So it's not applicable to removing a setting that's already scheduled.
Yes.
That would require.
And no one saw that.
No. we would sometimes, in some cases where we've put forward a new item in setting, an owner may, and this is happened, I think, it's suggested a slightly different setting. So there's an agreement here.
Where you would be negotiating stage or change that way you can get it.
I guess
Agreed.
by agreement for a new item.
The Commissioner said in paragraph 113 of the legal sections. To address the owner requested to remove a setting which is in the operative plan. So is that the situation that you're asking the question about?
Well, that may introduce a matter of scope, but yeah, I'm just trying to understand how the practice of not scheduling unless an owner agrees plays out in the scenario where someone may challenge the setting but not the item itself. Would that apply? Therefore, the setting wouldn't be scheduled because that doesn't have owner's agreement. It's the consistency of applying that practice, I suppose. Yes. Yeah. I can't recall. I don't know the specifics of that submission, but it would suggest that there's possibly a live issue in that case. Yeah.
And just on the matter of that, how does not scheduling a heritage item that has been assessed as being of heritage value, how does that align with section 6F when you say we are not scheduling it because the owner doesn't want it? That might be more a legal issue.
I mean, it's not a policy we put forward in the district plan. That's the reason why it's a I guess I would say it's a pragmatic way of working for efficient changes. And in the past, we've perhaps put forward larger numbers of buildings to be added to the schedule. But varying degrees of owner support. In some cases, owners have become distressed as part of that process. In other cases, there have been alternative legal agreements. Say the owner didn't support scheduling, but the owner wanted to retain their building. So there was an agreement outside of the district plan, a legal agreement that said that would not demolish the building. So there are alternative pathways. We just came to an agreed way of working, given our resources, that generally we wouldn't put forward places for scheduling unless there's an agreement. We can't get access to buildings to assess them properly, owner agreement, and often there's other matters at play. We like to get information from the owners that helps us to assess the state of the building.
I guess from my point of view, it'd be interested to cover this off closely. We have a technical appraisal rooted in section 6F as to heritage significance or not. Alongside that, we have somewhat pragmatic reality around notwithstanding that a particular item may qualify, if you like, based on the methodology for identification, but without owner agreement. That suggests that difficult. It doesn't change the heritage significance of the item or its setting. And I guess what I'm searching for is the part the pragmatic plays in the overall section 32 evaluation as to the appropriateness or otherwise of it. Sorry, directed legal counsel. You understand where I'm coming from?
Yeah, the other issue is that when you were speaking, you said generally. So is it a firm? Well, I'll use the word policy. Is it a firm policy or is it flexible?
It's not a written policy. I would describe it more as a way of working, a way of prioritising. I would be quite nervous putting it forward in the plan as a policy, because I think there are certainly circumstances where places would be of significance.
Yeah, that's not what I'm asking, but it's, the question is whether that is a firm practice that you don't list a building if you don't get owner's consent. We don't proffer it for listing. Are there exceptions to that?
I guess I can't really answer that question. There may be.
Let's follow that with the specific.
Sure.
One of the matters following on from this was in terms of Princess Margaret. That was your and that was one of the reasons there, which for a building which on your evidence is at least very likely to meet the heritage values, and it's owned by government owned, I'm presuming. But how much was that a factor in that decision that shouldn't be put forward for scheduling?
It was one factor, together with the potential engineering and financial concerns that the owner mentioned to us, but we didn't receive any detailed information on either of those matters. Plus, we had some initial research on the buildings and an impression that the likelihood is that it would meet the threshold significance-wise for scheduling. That assessment hasn't been completed yet.
Excuse me, sorry to interrupt. Would you all mind speaking up a little bit? It's just sorry.
It's bloody hard to hear. You all mumble. Not mumble, sorry. You need to pitch up 50% or put mics.
Miss Jagger.
Sorry, that sounded very rude. Didn't mean to.
I understand.
You're fine,
We'll
but
do our best.
most others, you're fine, but I'm near you. But you were very hard to hear. You were almost impossible to hear. And we are here on our own time, and we don't just want to watch. If we can Zoom, we'll watch it on Zoom. No one told me you were on Zoom. Communication is not great here.
Sorry, did you answer that question? You finished your.
Bruce Harding, I'm a stirrer, probably by some people's mind. And I think I know what you're talking about, if it's the Dan Rutherford property in Macmillan Avenue. And I'd love to talk to the commissioners, because the big issue I don't think anyone's
Just 1 second.
addressing is what's resale for the person. That's
Yeah, I don't want to
I
take
think there's,
yeah.
I'm not officially speaking and I'm out of order. I apologise.
We will try to speak up. I take your point.
I'm sorry that was over the top, my comment.
No, you're entitled to hear, so that's fine.
Thank you, sir. I appreciate it.
Sorry.
Right, well, yeah, my train of think's been disrupted. But we're still talking about that practice, if you like, and in terms of Princess Margaret. So there were a combination of factors. The owner's reluctance was one of them. Engineering, and it hadn't actually been through the proper assessment at that stage.
Yes, correct.
Right. So that predates. The council only take that detailed assessment when it's got past that initial stage, if you like.
We need a degree of owner support to enable to visit the property and undertake.
So they were the points you were making about that you can't get it if the owner doesn't want you in. So makes it different. Cool. Is that relevant to overall possibility of scheduling, or more to the fabric of the interior?
Well, to a degree, one can research and assess a place without visiting it or viewing it from the road. But in order to get a proper understanding of its heritage fabric, its degree of integrity and intactness, that visit would be best practice to undertake.
Sorry for interrupting.
That's right.
Thank you for that.
I've just got a couple of questions. One, can I take you into your 42A contribution evidence, where in relation to the Riccarton, the tea house, and I'm just trying to get my head around what I understand to be a now agreed position around changes with respect to the setting. So I think it's your appendix B and C. Have you got my image is the same size as yours and actually quite small. So forgive me if it's obvious, but what I want you to explain to me is where relative to your recommendation, which, as I say, I understand is now an agreed position, what is that outcome in respect to the modified setting?
So the modified setting in terms of what is in the operative plan, or the modified setting from what the submitter thought?
Relative to your recommendation for a change under PCPV. So I'm not so troubled by the operative. I'm interested now, where are you suggesting we take it? And I think it's Appendix C.
It is Appendix C.
Just not sure what the distinction is between the various colours, because I can't read it.
So if you look at the map on Appendix C, the blue dotted line is the operative setting.
Yep.
The green line is the reduction that I've agreed to and submitter has agreed to. Initially, the submitter sought, if you refer to Appendix B,
So it's a larger area.
line,
Yep.
which doesn't include, if you look at the green line, it includes the area which enables views out to.
Ah, yes, goes out towards the track. Yep. Yep.
And I considered that to be quite important to retain, because tea house was where the women could observe the races from, because they couldn't go to the grandstand as it served alcohol. So if the setting did not sort of extend to encompass those uninterrupted views and provide for the continuation of those, I felt that it wouldn't be
All right, I'm clear. Thank you. I'm clear on that.
It's a very more organic shape, which related directly to the moat, which is around the tea house.
That was the issue I was going to ask you. So your change incorporates the moat, the water features.
Yes, it does.
But it doesn't include, just so I'm clear, the entranceway in blue is not. That's what you're proposing. Yours is in the green.
And that is agreed. Sorry with the submitter. So I think I took that from you. Yeah, great. Thank you. Paragraph 17 of your evidence, your 42A evidence, where I think you're talking about in relation to the owner being or Health New Zealand. And you said that Penny Wells advised that the owner is not supportive of the building being scheduled as a heritage item, to see if there was any update. You had contacted her. Is there any subsequent conversation?
There was an email response soon after that, which said referred this to somebody and they'll get back to you, and I haven't heard.
Okay. And so I think I know the answer. In that situation, that would be taken as without agreement, if you like, in terms of the practice at this point. So if subsequently that something does emerge, that would be outside, or subject to some sort of future plan change or alteration down the track. Yeah. what I suspect we might find ourselves doing is hearing from some of the submitters in relation to Antonio Hall and Dewsbury, and then probably come back and maybe revisit some matters, having heard that. Now, it's a bit circular and it's risky, but I'm foreseeing that that could very well be the situation given the order of events we're having here. So, are you available tomorrow to be available should we need you? I know this is a generic request. I thought just you understand where I'm coming from. Yeah. That's all for me.
Yeah, I'm just, they're really just matters of clarification, but in terms of the Papanui War Memorial views, but you've identified the significance, you've addressed that in your evidence of paragraphs 17 through to 32. One of the issues I'm just want to talk to you about really is the potential inclusion which was sought by one of the submitters. The name escapes me, maybe Tucker, but one of the submitters who sought that extension to include houses on Windermere Street in particular. Yeah. Now, your view is that that's not appropriate. That's environmental reasons.
Yes, that's correct. I do discuss that.
It's in your paragraph 21 onwards, is it? 21 of your evidence in check.